Hello, everyone. Welcome to the webinar today. I'll just leave it a minute while we start to pile in. If you want to, pop in the chat where you're watching from and just to give us an idea of where you're watching from today. Let us know if you can hear me. If you can't hear me and I'm just mute, let me know that as well, but you should be able to hear me at the moment. Cool. Hi, Rebecca. Hi, Jennifer. Fantastic. I might kick off. So hello, everyone. I guess in the wake of some of the recent high-profile privacy breaches at Optus and Medibank, ADIA and CIE Legal, in conjunction with AusActive, we're going to present Know Your Privacy Obligations, working under the Australian Privacy Act. So this presentation will cover what you need to know about meeting minimum privacy law obligations and what you can do to mitigate risk. And to present that today, we've got Sarah Campbell. She's the Chief Executive Officer of Australian Data and Insights Association, or ADIA. Sarah's been the Chief Executive Officer for over 11 years. Sarah manages the day-to-day running of the association. She is a communication and stakeholder engagement specialist, has over 20 years experience in corporate, government and public relations, and prior to joining ADIA, worked for some of Australia's most recognised organisations, including Foxtel, ABC TV, News Corp and UNICEF. So welcome, Sarah. You'll know what you're talking about. We've also got Andrew Ma, who's a partner and co-founder of CIE Legal and is the ADIA Legal Counsel. Andrew is a workplace relations, employment and privacy law specialist and has been with ADIA for 15 years. So I think we're all in good hands. Anyone has any questions, pop them in the chat along the way, but if it gets missed, we'll circle back to those at the end. But I'm going to pass over to you, Sarah, Andrew. Good luck, and I'll pop in again at the end.
Thanks, Dan. Thank you very much. Great to see so many people on today. Thanks for joining us. And look, we're delighted to be here today with AusActive, and thank you, AusActive, for inviting us. So we're going to talk about all things privacy related. However, before I go into that, I'd just like to acknowledge the Gadigal people upon the land whose land I work and live, and pay my respects to elders past, present and emerging. So look, who is ADIA? Before we kick off, I thought I'd just introduce you to the association. So like AusActive, we're a membership-based organisation. We have 100 member organisations spread across Australia. They conduct market and social research. And have over 5,000 employees across those 100 companies. It's a $3 billion industry, and our members conduct research for commercial and government entities. So we're talking federal, state, local government agencies, and also the top ASX companies, along with many more in terms of commercial research. So look, our members also work under a privacy code, which was the first actually and only registered privacy code in the country. It's an industry privacy code. We're the administrator of the code, and it's a condition of membership that our members sign up to it, and it's adjudicated because it's legislated and registered. It's adjudicated by the Office of the Australian Information Commissioner, the OAIC, who you'll hear us refer to quite a few times today throughout the session. So look, so as I said, and as Dan very kindly introduced us, this is in conjunction with CIE Legal. Andrew's been with us for over 15 years and is a workplace relations, employment and privacy law specialist. G'day, Andrew. Thank you.
Thanks, Sarah.
So what are we looking at today? So look, we're looking at privacy and the fact that it's not dead. We're looking at the APPs, which are the Australian Privacy Principles, and there's 13 in total. We're looking at protection under the Notifiable Data Breach Scheme. We're going to cover off do's and don'ts, just to give you a bit of a ready reckoner, and also what's changing in privacy. And if you have any questions, please pop them into the question Q&A function, and we'll try and get to them at the end of the session, or we'll certainly do our best to cover all of them. So look, I just thought I'd frame the conversation today, or the session, with the fact that privacy isn't dead. And I'm not sure if you knew about this, but in 2010, Mark Zuckerberg came out, who is obviously the co-founder of Privacy, and now, which is now called Meta. He came out and said privacy is dead, which was quite alarming, obviously, to a number of people. But we know now that privacy is very much not dead, given that the Medibank and the Optus breaches recently, and even before that, I'm not sure if anyone is familiar with the Cambridge Analytica breach, which happened in 2016, when Cambridge Analytica, in conjunction with Facebook, actually harvested 87 million profiles, Facebook profiles, and used them in the Trump campaign in 2016. So look, that all became exposed in 2018, and needless to say, Facebook was fined $5 billion. Cambridge Analytica filed for bankruptcy and then had to close their doors. And then that kind of went away. And now we've got here in Australia, the Optus and Medibank breaches that have been top of the pops lately. So, Optus breach, 9.8 million customers were affected, and Medibank private. Even this morning, driving, I heard that even the last of the files for the Medibank breach have just been released on the dark web. So look, that's not going away anytime soon. They're both being investigated. Office of the Australian Information Commissioner, ACCC, the Australian Communications and Media Authority. So look, it's just not a very pretty picture for either of those organisations. So look, off the back of that, you may have heard Mark Dreyfus, who's the Attorney General, come out and say that they're fast-tracking privacy reform. So Andrew and I have been following this very closely with our Privacy Compliance Committee. And yes, it's just passed both houses of Parliament. So it's going to be, we anticipate it's going to be in field and legislated early 23. What does that mean? It kind of means big teeth for privacy law. So, the penalty up until now has been 2.2 million for a major data breach or a notifiable data breach. Now they're looking at over 50 million for companies. So watch this space. It's just not going to be a very pretty scene next year for any companies that have major data breaches and who aren't showing due diligence. But look, Andrew's going to talk about this later. So look, what are the APPs? I'm going to hand over to Andrew Marr. Thank you, Andrew, who's going to step us through the 13. Thanks, Andrew.
Yeah, thanks, Sarah, and thanks to you all for having Sarah and I here today. As Sarah said, it is very timely considering what we're seeing in the news with frightening repetition and regularity is the issue of data security and especially data breaches, especially in the context of organised crime being involved in these systematic breaches. So it is very important to be mindful of your obligations, because it really could come home to roost when you least expect it, through the work of bad actors and hackers trying to access the personal information that you hold. Excuse me. Now, I suppose for some organisations amongst you, or represented amongst the audience here today, at the moment, privacy law at a Commonwealth level may not apply, simply because there is a $3 million sort of minimum turnover for most businesses to be part of the privacy regime. There has been long-standing talk of removing that exemption or that exclusion, but as of yet, and also even in the context of the most recent amendments that are on their way, that hasn't been removed. But having said that, there are legal reasons why many companies should comply with their privacy obligations, but obviously there's some very significant reputational reasons as well why why you'd want to make sure that you are, insofar as your resources allow you, to engage in best practice in terms of privacy compliance. You, as an industry, are going to hold substantial amounts of personal information, and in some cases, and I will talk about what the definition is of this shortly, but you will be holding sensitive information as well, which is a sort of more highly protected subset of personal information. So the Australian privacy principles, now what are they? They replaced the national privacy principles that were in place prior to 2014. But the way the Act operates is it creates, while the Act itself, the Privacy Act, Commonwealth Privacy Act, establishes the Office of the Australian Information Commissioner and deals with all sorts of mechanical provisions. The obligations themselves have all been largely located in one spot, which is the Australian privacy principles. It is a principle-based form of regulation, which means that it's not going to be simply, you should not do that, you should not do this, and define clearly what this is. I mean, if you look at, for example, traffic infringements, it is, if you're parked in front of a no standing zone, you get a fine of this. It doesn't work in quite that way. It works really on the basis of a set of sort of broader principles that should, in some cases, they end up being quite prescriptive, but what they do is they provide a sort of a set of sort of overarching guidelines or ways of thinking almost in terms of how you deal with privacy. And if you look at what the purpose of the APPs is, or the purposes perhaps are, it can give you a much better sense of the way that the Office of the Australian Information Commissioner will deal with complaints and allegations of interferences with privacy. The real focus about it, the whole privacy regime, and I think if you don't take away anything else from this seminar today, this is the important takeaway message, is firstly, you need to deal with data only to the extent that your organisation really needs to deal with it. And you shouldn't be keeping data any longer than you really reasonably have to. And that will expose you, even if you've got all the best cybersecurity measures in place in the world, it's not going to necessarily protect you from being found to have interfered with privacy if you've got an abundance of personal information that you're holding on your system that you shouldn't really have because it's either not relevant anymore or you shouldn't have collected it in the first place. The other part of it is that consent and transparency in the way that you deal with information is really at the heart of the APPs. And that is something that every time the Information Commissioner and Information Commissioner talks about it, or the Privacy Commissioner previously talks about these sort of issues, that really is at the forefront. So people should have an understanding about how their personal information is being collected, how it's being stored, how it's being used. And the information, the Australian privacy principles, in a lot of ways sort of map that life cycle of data from its sort of collection through all the way to its sort of storage and correction and what have you, and access by those whose personal information you hold. So the APPs from 1 to 13 do have sort of it's not entirely logical, but they do have at least some sort of internal logic in terms of how they're all set out. And you can look at the collection of personal information is earlier on in the APPs, and then the issues of security and access and what have you are down the tail end. And you'll see when I talk through them, which I'll try and make as brief as possible. Bear in mind that there is a lot of commentary available, and if you want to go to the OAIC website, there's a lot of good information available, which is oaic.gov.au. But the I'll try and just give you a little bit of a snapshot of what each one means in terms of an organisation. So these are minimums, and also in the case of ADIA, there's a privacy code that sits on top, but these are going to be sort of the benchmarks against which you should judge your own privacy compliance. And if you want to be more privacy compliant, then it's never going to do you any harm in terms of reputation and minimising risk. So these privacy principles apply to the Commonwealth and most private sector businesses. Subject to that, there's some exceptions, and prior to that, subject to that exception with the 3 million turnover. There are a range of state and territory statutes that also deal with information protection and data privacy. And I just have a list of those there. I see from your comments earlier on that we do have a very large geographical spread today. So as you'll see from various states and territories, there are different acts that apply. But for most of you, the Federal Privacy Act and the APPs will be the go-to point. Just so you know, the state and federal laws will always take precedence over industry guidelines, and they'll also take precedent over common law contracts. So if you've got a contract with a person who's provided you with their personal information that says privacy, the APPs will not apply to the holding of your information, and you consent to us, doing whatever we want with it, and you waive your rights under the Privacy Act, that won't be operative because you can't contract out of these privacy principles. Federal and state privacy commissions do work together to ensure that legislation complements rather than conflicts, and it's more of a matter for ensuring that any companies working for state government agencies are clear about which piece of legislation applies. So a number of our members will, when they're doing work under state contracts, will actually be covered by a different set of data protection principles. But again, if you do focus on what the APPs provide and comply with those, then in most cases, you'll be sort of covering the field in terms of compliance. But as it says there, if in doubt, comply with the most stringent piece of legislation. So what do we mean by privacy? Now, most of you will probably have a bit of a sense of what personal information is, but the Act does actually contain a definition, and it's defined as information or an opinion about an identified individual, and that's important, identified, or an individual who's reasonably identifiable. So not only does it need to, it doesn't just need to sort of say, for example, or it doesn't only apply where you've said, my name is Andrew Marr and my email address is amar@cialegal.com.au. Okay, that's identified because you know who I am. But it will be also where you have enough data that if you wanted to stitch it together in certain ways that you could identify the person, it may well be that that data set, even though it doesn't expressly identify the person, may well still constitute personal information and therefore be protected by the APPs because it can be reconstituted with relative ease, perhaps, to be identifiable personal information. Excuse me. So the sort of things that constitute personal information will be things like name, age, date of birth, phone number, email address, photographs, credit card details, salary information, and also opinions. Sensitive information is a subset of personal information, and it is treated and sort of viewed by the OAIC as deserving special protection. And also some of the APPs deal with it in a way that is slightly different from the way that they deal with what I generally call garden variety personal information. So sensitive information is information about an individual's racial or ethnic origin, political opinions, membership of a political association, religious beliefs or affiliations, philosophical beliefs, membership of a professional or trade association, membership of a trade union, sexual preferences or practices, criminal record, or health information. I suspect that a number of the organisations who are participating in this webinar today will be holding some health information of your sort of customers, members, clients, and it may range from not particularly sensitive information to if people, for example, had to identify whether or not they've got diabetes or heart problems or whatever that might impact on their capacity to participate in the services you're offering. You will have very specific obligations and heightened obligations with respect to that particular information, as opposed to just their contact details or name, telephone number, and things like that. So you will probably be holding, in most cases, a combination of sort of what I call garden variety personal information and sensitive information. As I said before, there are 13 APPs and they follow the life cycle of data. Number one really sets up an overarching obligation with respect to privacy that, that organisations bound by the APPs have to comply with. So the first one is an organisation must have a clearly expressed and up-to-date privacy policy and complaints procedure readily available. Now that is more often than not available on companies' websites. And if you don't have one, even if you are not covered by the APPs, it is still a good idea to have some form of privacy policy, because if nothing else, it gives people a little bit of comfort to know that if they do provide their personal information to you, in return for you providing services to them, that it will be treated at least in some sort of systematic way, as opposed to sort of, you know, grabbed at an ad hoc basis and stored however which way. And also under the APP, one organisation must take reasonable steps to implement processes that will ensure that the agency complies with the APPs. So it's a positive obligation to turn your mind to obligations under the APPs and to look at the appropriate mechanisms for implementing them and complying with them. APP2 simply creates the right of an individual to interact with an organisation anonymously or pseudonymously. What that means is if you do not want to identify yourself by name and you want to use a pseudonym, or you want to remain anonymous, you have the right to request that and to proceed on that basis. However, under APP2, an organisation then has the obligation to explain to you what the implications of that are, because it may well be that in a number of circumstances, and in fact, you know, probably a majority of circumstances, proceeding anonymously may not be possible, and the organisation needs to advise you of what the implications are if you decide to proceed only on the basis of anonymity or using a pseudonym. APP3 deals with, it's sort of the gatekeeper for the collection of personal information. So in terms of garden variety personal information, the collection of personal information by an organisation must be reasonably necessary for or directly related to one or more of an agency's functions or activities. You can't just collect personal information willy-nilly. It does actually have to be connected to your business operations. And there is a growing focus on not only the fact that you need to be authorised in that sense to collect the information, but the breadth of the information itself will be under scrutiny, because you only need authorised really to collect the information that, not personal information in general from a person, but the specific personal information that would be reasonably necessary for or directly related to one or more of the agency's functions or activities. When you're looking at sensitive information, it must not be, it must not be reasonably necessary, it must be necessary. So really it has to be sort of critical or crucial to the operation of the organisation, and it must be collected with direct and informed consent. Whereas I'll talk about in a second that personal information of the garden variety, the consent issue is a little bit more, it's a little bit more rubbery. APP4 deals with unsolicited personal information that under the old national privacy principles wasn't dealt with. So this is information that you've received that you actually weren't searching for or you weren't seeking to collect. And unsolicited personal information could be things like unsolicited job applications. So you've got all these details that come in on a CV that you haven't solicited, and now you've got obligations in how to deal with it. So it's treated in the same way in terms of the protections that it's afforded as personal information that it is actively collected or solicited. In most cases, if it's unsolicited and there is no operational reason to retain it, then our recommendation is always to delete it, because the more that you have sitting there that isn't really sort of authorized by the APPs, the greater risk you have that should something happen like a hack, that you are going to be potentially exposed to fines and penalties for interferences with privacy by not complying with the APPs. APP5 is probably the most prescriptive and the only one of the APPs in some ways that isn't really principle based. It's actually quite prescriptive in terms of what it requires. So it mandates the use of a collection statement, or what's known as a collection statement, that has a certain amount of mandated information in it that is provided to people at or as soon as practicable after the time of collection of personal information from them. So a collection statement needs to include information about a company's APP policy, which will be their privacy policy, and usually would be, a copy of the privacy policy can be found on our website at www.whateverdataandinsights.com.au. Who the company is, that's the collector of the company that's collecting the information, who the company is and how to contact it, the purpose of the collection, any collections from third parties. Now that might be something like, we are contacting you because we've bought a customer list from a third party, and that's why we're contacting you. So not only are you telling them that you are collecting information from them now, but that you've already collected information in relation to them from a third party prior. The consequences of non-collection, and again, that sort of ties back almost to that APP2 pseudonymous or pseudonymous and anonymous data collection. You've got to explain what happens if a person refuses to provide the information to you. The complaints handling process that again can be dealt with in the privacy policy, and also potential overseas disclosure. So if the information is going to be held overseas, either on servers overseas or by a third party entity in another way, you will need to make some sort of disclosure about that, and that also obviously includes sort of cloud-based storage where those servers that support the cloud are overseas. So you've collected the personal information and you want to do something with it because you've collected it, and you've no doubt collected it for a reason. And use and disclosure are effectively the two main ways that it is expected that information will be dealt with. So different, more stringent obligations apply to the use or disclosure of information. And again, that is very much a consent-based situation. If you want to use someone's sensitive information, you really need to gain their consent for those uses or those disclosures. There are limited exceptions, in fact, to a number of the APPs, and they deal with really where it's legally required. It's a law enforcement action, it's an emergency type situation. I won't go through them in any great detail, but just be mindful that there are exceptions to a number of the APPs that deal with these kind of legal and emergency situations. So if an organisation holds identifiable personal information about a person that was collected for a particular purpose, the primary purpose, the company must not use or disclose it for another purpose without consent. But you do have the capacity to use information where, especially if it's not personal information, if you've got garden variety personal information, you've collected it for a certain reason, there is some capacity to use it for a related reason to the primary purpose of collection without consent, especially if a person's going to reasonably expect that information will be used in that way. The best example for those is that someone signs up to your courses, signs on to your studio, for example, for Pilates or whatever, whatever they're subscribing to, and they provide you with their contact details and what have you, and you send them information about upcoming deals or upcoming events and things like that. So although they haven't said to you, I'm giving you this information because I want you to send me marketing information and information about things that are going on and offers that might be available to me. It's reasonable. It's sufficiently connected to the primary purpose or related to the primary purpose that will be authorised by that original consent of providing the information. If I provide information to access a product or service, it should be reasonably anticipated that I may receive some sort of marketing in relation to that. However, I wouldn't expect that if I provided my contact details to Telstra to sign up for a phone, that I would get a call from GE saying, do I want to get credit or something, or from a bank saying, do you want a line of credit? Because they've actually say, we know that you've recently signed up for Telstra because Telstra's informed us. You don't expect that it's going to be used by a third party, but you do expect in most cases that it will be used by the party to whom you provided the personal information with the view of obtaining that product or service. So APP7, and this ties back into what I was saying just then, deals with direct marketing. So it prohibits organisations from using or disclosing personal information for direct marketing purposes, except in specified circumstances where personal information has been collected directly from an individual and the individual would reasonably expect their personal information to be used for the purpose of direct marketing. So that ties back into APP6 as well. There would be an expectation that if you provide your information to an entity for the purposes of product or service provision and you're contacted in a direct marketing sense, it's not going to be that surprising. It ties into the Spam Act as well, which I won't go into today, but there are obligations under the Spam Act as well, including things like compulsory opt-out. But they dovetail together, the direct marketing and the Spam Act, depending on the form the direct marketing takes. There is a separate APP dealing with cross-border disclosure, and this makes the disclosor accountable really in terms of maintaining protection for that data when it is being transferred to another jurisdiction. So what would normally happen is you'd have sort of SLAs or service level agreements with those who you are disclosing the information to that would ensure that the protections provided to that information are at least commensurate or equivalent to what obligations would be applicable in the Australian jurisdiction should the information have been dealt with here. In certain other jurisdictions, such as Europe, where the GDPR is in place that is arguably more stringent than the Australian privacy principles, this won't be so much of an issue because they will generally have their own obligations. But you should really be making sure at any time if you disclose to a third party overseas that you are making sure that they have the obligations that are similar to the obligations you have here. Now, I should add, a disclosure does not occur if it's between related bodies corporate. So if you've got a branch in Australia and you are disclosing it to head office in the UK or in the US, it's not going to be a cross-border disclosure because it's actually not a disclosure because they're treated as a single entity for the purposes of holding and using that information. It's a simple one. An organisation is prohibited from using a government-related identifier as its own identifier. So basically things like do not store information with the reference point of someone's tax file number, do not store information with someone's driver's license, Medicare number or something as the reference point. If you want to put some sort of code identifier, generate one yourself rather than using that because that is prohibited. So quality, this requires organisations to take reasonable steps to ensure personal information it collects, uses or discloses is accurate, up-to-date and complete. And information, this is one thing, one of the APPs that relates to the holding of information over an extended period of time when it's no longer relevant. To use an example close to home, with the most recent Optus data breach, my wife found out that her driver's license had been part of the data that had been hacked and improperly accessed. Now, we hadn't dealt with Optus for a number of years, and I can see no reason why they should have held on to that. Now, it was probably going to be accurate because at that stage, her driver's license number hadn't changed. It may well now as a result of the hack, but you know, it's not necessarily up to date, and it's not necessarily accurate because they've held it too long, firstly. And secondly, what an organisation should do periodically is if they're holding your information, you'll see this where you're, you know, renewing subscriptions and things like that. It might say, please check your data, you know, your address is this, your phone number is this, the email is this, please just check to make sure this is still current. And that will actually be helping them comply with APP 10 to make sure that the information that they've got and they're holding, and holding hopefully for good reason, is up to date. As we've all seen recently, almost, you know, you cannot always factor out that your data will be accessed unlawfully or improperly. Every time a new security measure is implemented, there are hackers working furiously at trying to get around it. It's just the nature of the beast. But an organisation must take reasonable steps to protect personal information it holds from misuse, interference, and loss, and from unauthorised access, modification, or disclosure, including, you know, cyber attacks. You need to have at least sort of, you know, industry standard data protection measures in place in terms of you holding sensitive information, whether it's encrypted, whether it or not it's actually in a de-identified form where the encryption will only allow it to be re-identified. So even if the information, some of the information itself, it's not itself encrypted, the fact that it needs a data key to link it to the identity of the person whose information it is. Because bearing in mind that if it's not identifiable in its current form, then it's not personal information protected by the Privacy Act. So you've got to take those sort of measures to protect the personal information, and especially the sensitive information that you hold as an organisation. Access, this is always a bit of a headache. Organisations are required to respond to requests for access of personal information within 30 days. There are exceptions that apply, including freedom of information exceptions, and access should be provided in the requested manner as long as it's reasonable and practicable. The individual should not be charged a fee for it, and written reasons for the refusal and a complaint mechanism need to be provided. Now, normally they'd be in the privacy policy. I should say, and I didn't mention at the start, that there are certain records that are exempt from privacy protection, and employee records are a current exempt category. So if you've got records that you're holding for the purposes and related to an individual's employment, and that does not include a job application because that's prior to their employment. But if you're holding records as an employer that relate to the employment of an individual, and that includes a former employee, they are generally going to be exempt, and therefore they cannot necessarily go back and say, okay, I left your organisation, you know, 6 months ago. I want to have access to all the performance notes that you made about me that you would hold on file, or any of the material that you have about me on file. A lot of employees think they can access it, but they can't. So that's just something to bear in mind, that if you're covered by the APPs and you're holding employment records, they may not actually be subject to this regime. And this ties back into APP 11. Organisations are required to take reasonable steps to correct personal information to ensure it's accurate, up-to-date, complete, relevant, and not misleading. If the company is satisfied it needs to be corrected, or the individual requests correction. So if you know that you're holding information that is actually incorrect, then you probably should be either deleting it or seeking to rectify it. So organisations need to respond to a request to correct within 30 days. And again, complaint mechanism and written reasons for refusal. So that takes us to the end of the APPs. And what I might do is pass you on to Sarah just to talk about the notifiable data breach scheme, because this is something that is important that everyone is aware of, because it is going to be relevant in a situation where you've been hacked, for example, and potentially sensitive information has been obtained by a third party. So I'll pass on to you, Sarah.
Thanks, Andrew. Thank you. Well done. It's always you need a bit of a breather after those 13, but well done. Oh goodness, why is that not going through? Okay, so the notifiable data breach. So this came into effect in 2018 and was an amendment to the existing Privacy Act. And essentially, as Andrew was just saying, it gives mandatory force to the whole data breach notification obligation, which basically means if there is a data hack or privacy breach and any respondent and or person that you've held data on is at risk of serious harm by that data breach, then you are legally required to notify the Commissioner, the OAIC, and the individual, because if an individual's personal information is held by your company and it's breached, as we were saying, whether by hack, by accident, or by design, notifying that individual quickly can help mitigate any risk to them. So basically, you are obliged under law to notify them ASAP. So as we were saying, the fines currently are up to 2.2 million for a company found to have a major data breach. But as we were saying earlier, that's going up possibly next year. So look, we'd just like to include this because this is an OAIC report that comes out each quarter for the notifiable data breach scheme. So this is obviously January to June 22, and it just shows you the sources of the data breach. So malicious or criminal attack is right up there at 63%, and human error by 33% just for this the January to June period. And then it gives you a bit of a cyber incident breakdown. Ransomware is right up there at 31%. So, hacking, demanding Bitcoin or whatever it might be, similar to the Medibank private hack recently. There's phishing, compromised or stolen credentials, that's up around 25%. But I always find it fascinating just looking too at the top causes of human error breaches. Everyone's human, we've got staff, people make mistakes, it's not by design, and you can't really blame them, but things happen. So the personal information emailed to the wrong recipient is at 38%, unintended release or publication 24%, and again personal information mailed to the wrong recipient at 8%. So Andrew, would you like to just touch on the Commissioner's powers, which might be changing anyway under the new
Yes, I think they will be changing.
Reform, they will be changing, yes.
They will be expanding. So the Commissioner's current powers include the ability to investigate a potential privacy breach without receiving a complaint. So it's what's called an own motion investigation, as well as in response to a complaint. Now, the reality is the OAIC has finite resources as a statutory authority and have generally been really reactive rather than proactive in this space. It doesn't really have the resources to go and chase too many rabbits down too many rabbit holes. So most of them are in response to a breach. And therefore, a breach and a complaint about that breach. So can I just go back quickly to that?
Sorry, beg your pardon.
So a wider range of action can be taken if a breach of the act is substantiated, whether as a result of an OMI or a complaint. Written undertakings, well, it says can now be enforced. This is the changes that came in after the initial iteration of the Privacy Act. This is back in 2014, and civil penalties are available for serious or repeated breaches, but they are very much the subject of the new amendments that will be coming into operation as soon as they receive royal assent from the Governor, or the Governor General.
Thanks, Andrew. So look, this is just a bit of a ready reckoner that we like to present our members, and we just thought this would be really handy for you, for your membership at AusActive as well. So the privacy do's and don'ts. So, this is a bit of a recap. Do ensure that you've got appropriate systems and processes in place to order, because privacy breaches and data hacks, if you've got the right information and data security protocols and policies, and firewalls in place and antivirus protections in place, then hopefully you can mitigate your risk. Don't collect more personal information than is necessary or relevant. As Andrew and I have been saying, if you can't protect it, don't collect it. So, I just think that's a really great catchphrase just to keep in the back of your mind, because the more you have on file, whether it's current or past, information, the greater risk that it poses for your corporation or organisation. Make sure you tell people what you're going to be doing with that information that you're collecting from them. Don't use information for an unrelated secondary purpose without their consent. Don't disclose personal information unnecessarily. Be careful what you do with it. Do give people access to their information if they ask, unless there's proper grounds under the APPs not to. Do keep your information free and secure. Don't keep it for any longer. I mean, with research, most of our members would always de-identify the minute the project, in fact, all of our members would de-identify information that they have on file the minute the project has been completed. So don't keep any information that you don't need, basically. Don't disclose information to overseas recipients in countries without equivalent privacy regimes and legislation. Again, that's a protective measure that you can enforce within the company. And do make someone responsible for privacy in your organisation. All of our member organisations have a privacy officer, and their job, obviously it's a secondary role for a lot of them, but their job is to make sure that the company's policies and protocols are in place for privacy. And again, it just helps mitigate risk. So this is a privacy management system that the OAIC produce and publish. So it's about embedding a culture of privacy that enables the organisation to comply. Make sure you've got the right processes in place. Do a bit of an audit once a year. Our members undergo privacy audit training, and we've got guidelines all around, privacy do's and don'ts. But, just evaluating what you're doing around the privacy space is really helpful and important. And enhance, your response to privacy issues is so important, so important. I mean, if you do have a notifiable data breach scheme, it's not necessarily, if you've done due diligence and your organisation has done everything in its power to make sure that you've got the right protocols in place, then at least you can go hand on heart out to your clients and the OAIC and the Commissioner and say, look, we were doing due diligence. Here's what happened. It wasn't really our fault, and we've been doing everything in our power to protect our clients. It's those organisations that respond poorly that lose trust, and trust is easily lost. So what's changing? Andrew Mark, do you want to run us through what's changing, please? Thank you.
Okay, thanks, Sarah. So the Privacy Legislation Amendment, Enforcement and Other Measures Bill 2022, which will soon become the Privacy Legislation Amendment of Enforcement and Other Measures Act 2022, I suspect, has now, as I said, passed through both houses of Federal Parliament, and now simply awaiting the sign-off from the Governor General, which will be a formality and will put it into effect. The most sort of startling change, I guess, is the penalty regime. It has really expanded very substantially. So where it was really sort of 2.5 million for a corporation for serious and repeated interferences with privacy, so breaches, it's now going to be 2.5 million for a person other than a body corporate, which means a natural person, an individual. 2.5 million for a breach, so that would be effectively, by a sole trader. And for a body corporate, an amount not exceeding the greater of. Now, this is the bottom end. The greater of 50 million, 3 times the value of the benefit obtained. Now, that's going to be one where if you, for example, had grabbed all your customer data and sold them, well, then that point might come into play. But in most cases, especially in the case of things like, a hack where you've kept information that you shouldn't really be keeping, that one's not going to be that relevant. Or if the court cannot determine the value of the benefit, 30% of the adjusted turnover in the relevant period. Now, the relevant period, I'm assuming, is the period that you actually held the data. So that which is impacted by the breach. So you're looking at 50 million up, and that's not going to depend on the size of your organisation. If you're a body corporate, and again, it's that $3 million turnover, you're in the zone. And I think that 3 million turnover exemption at some stage may be removed as well. So it is really, there are 50 million plus good reasons if you're a corporation, and 2.5 million if you're a sole trader and you're actually within the regime, so you're trading more than 3 million a year, which if you're a sole trader, I heartily congratulate you, but certainly wouldn't be that uncommon with body corporates. There are very, very good reasons to get this right. Sarah, can I get you to move on? Now, enhanced enforcement powers. The amended Act will provide the OAIC with enhanced enforcement powers, including expanding the type of declarations that the Commissioner can make in determination at the conclusion of an investigation. So that's really going to affect remedies and I suspect binding remedies that the Commissioner can order, not just in terms of penalties, but in terms of sort of directions in terms of perhaps reparations or remedial actions that might be required from the organisation that has been found to be in breach. It's extending the extraterritorial jurisdiction of the Privacy Act to ensure that foreign organisations who carry on a business in Australia must meet the obligations under the Act, even if they do not collect or hold Australian information directly from a source in Australia. Previously, when you looked at the extraterritorial operation of the Act, we talked about a sort of Australian connection, and it wasn't really that clear that if you weren't holding Australian individuals' data, whether or not you'd actually be covered, but they're trying to expand it, so it's more inclusive. It provides the Commissioner with new powers to conduct assessments and new infringement notice powers to penalise entities for failing to provide information without the need to engage in litigation. Previously, if you hadn't complied with effectively a notice to produce, the Commissioner would have to take you to court. So now it looks like they will be, like being issued a fine on a piece of paper by, a traffic warden. So that's going to be interesting, and that will hopefully, I suspect from the OAIC's point of view, help progress investigations where people appear to be stonewalling. It will give them a good incentive to actually comply. And the sort of second last part is amending the Act to enhance the Commissioner's ability to share information really with other authorities, and also the power to disclose information to enforcement bodies, alternative complaint bodies, state, territory or foreign regulators, privacy regulators, for the purpose of the Commissioner or the receiving body exercising their powers. And also providing the Commissioner with the power to publish a determination or information relating to an assessment on the Commissioner's website. And what it does is it makes a little carve out so that the Commissioner is not kind of itself as bound by privacy as it would have been when publishing these kind of determinations. Previously, as it was bound in all senses by the privacy obligations in the Act, it had to be very careful about what it could publish, but it's going to have a little bit more latitude than it used to. Lastly, the amended Act will amend the ACMA Act, Australian Communications and Media Authority Act, to expand that authority's ability to share information with any non-corporate Commonwealth entity, which are generally, various agencies or authorities that are part of the Commonwealth, part of the Commonwealth government, responsible for enforcing Commonwealth laws, where the information will assist them to perform or exercise any of their functions or powers. So it's not quite clear what that's going to actually mean in practice, but like so many new provisions in legislation, I think the proof will be in the pudding to see what actually ACMA will end up doing. But as Sarah said before, it has become involved in a multi-agency effort to deal with a couple of these very high-profile data breaches we've seen recently. Okay.
Okay, questions. Do we have any questions? There's quite a few things in the chat, but I haven't had a look. Dan, have you got any questions? Anything coming?
Perhaps you can moderate.
Yeah, I'll pop my head in. Nothing in the chat that I can see. I think everyone might have just been a bit enthralled and listening along. But yeah, I guess while we've got a bit of time, if anyone in the chat or in the webinar does have any questions, please pop them in. But that was very informative.
There's
Sarah
a
and
lot
Andrew.
there, isn't there?
so much
There's
to
so
do.
much there.
And everyone's
Yeah.
thinking, Dan, can we talk about something fun next time?
Yeah, please.
No, I hope everyone enjoyed that. I definitely took something out of it. We do have a question from Rachel. What about private claims in court of breach? Sorry, what about private claims in court of breach by an individual sole trader? I'm not. That doesn't make. I'm not 100% sure what that means myself. But Sarah, Andrew, does that?
Yeah, look,
resonate?
in legal proceedings, again, they'll be form certain exemptions apply when you are dealing with litigation. So information, if someone has gone after you or as a sole trader, or you're going after a sole trader, well, then certain interference with privacy obligations won't necessarily be triggered simply because information's being included in court documentation, for example. I don't know if that's really what's being asked, but they will fall into one or t'other of the exceptions generally in the APPs.
I hope that.
Andrew, just on the reform. Sorry, Dan, did you finish?
Oh, no, I was just going to say I hope that helps, Rachel, but I'll let you go.
I was just going to say, because now we have to wait. Now that the reform's been passed in terms of the privacy law changing next year. Is there any indication, Andrew, how long that might take? Like when it will become law? Those changes?
Well, the Act says they come into effect upon receiving royal assent, and it may well be that that's going to happen before Christmas.
Yeah, right. Yeah, okay.
So soon.
A couple other questions. One from Martin here asks, I'm a small business under 3 million member data held in cloud by software provider. Do I have any obligations with that data?
If you're under 3 mil, the APPs won't apply to you unless you're in the business of dealing with information for commercial benefit, and your members in general won't be, because that's not the services that they provide. So no, generally you don't have those obligations. But again, to some degree, maintaining sort of at least sort of bare bones compliance with the APPs is a good idea, especially, as I said, reputationally it's important, but also if the exemption is removed subsequently, you'll be in a good position just to continue the way you're doing things because you're doing all the right things anyway.
Yeah. And one thing that we often say to our members with the cloud, I mean, we all kind of use this within the cloud, it's in the cloud, but the cloud is a server somewhere, like it has to be a server, whether it's in Australia or overseas or wherever. So it's always good just to know where that server might be and that you can trust that supplier of the cloud.
Yeah, that's exactly right, Sarah.
Yeah.
And making sure that they do have industry standard cyber protection measures in place. So, if you see someone says, oh, look, it's $1 a year, store 10 terabytes with this, then I suspect that they're probably not doing the things they need to do.
Yeah.
So, there's a little bit of a buyer beware situation there.
Yeah.
Another one that maybe a couple people are asking is just about business insurance to cover privacy breach. Does that need to be a special category of insurance, which I do believe there is? But yeah, if you don't mind.
Yeah, there is something called cyber breach, the cyber insurance that manages and oversees cyber breaches. We recommend to our companies a company called Gallagher Insurance that do cyber insurance specifically. Yeah. So it's quite different from your public liability and things. Yeah.
But having said we recommend it to our members, we're certainly not holding them out as
oh no, there's there'd be plenty of other suppliers out there, other insurers out there that would offer cyber insurance. Yeah, absolutely. Yeah.
I think that we just might have organised a group buying discount or something with them.
Yeah, that's right.
So
yeah, that's exactly right.
So certainly go out and test the market yourselves.
Shop around.
If we've got time for a couple more, Jason asks, prior to collecting data, I guess our members will do like a pre-exercise questionnaire of our members and ask about, things. Do we need to ensure clients are directly referred to our privacy policy rather than having it linked as a link in the footer? So I guess is that something they need to be doing upfront, or is it something you?
No,
hope
a link would be enough probably now. If it's being done in hard copy, there probably should be a collection statement accessible on the hard copy, and whether it's over the page or something like that, you'll find that most times you sort of sit down, even if you go to a local GP and you're filling in hard copy or whatever, there should probably be a collection statement and say, you know, it might say then that our policy is available at, you know, www. whatever. So you don't need to have the whole privacy policy there, but yeah, you should make it clear on that document and in a footer, not sort of, you know, in 0.5 millimeter writing, but in legible writing that should be identifiable where the privacy policy is accessible.
Great, that's very helpful. Rachel asks again, is there a restriction on which sole traders will be covered in the new / amended Act?
No, it still will be that $3 million threshold. If your annual turnover is under 3 million, then you're still going to be exempt from compliance with the APPs.
Yeah. A few more questions coming. So do you guys, how are you guys for time, Sarah and Andrew?
I'm okay.
Yeah, no,
Okay.
it's fine. Thank you.
All right, we might just go through a few more. Martin asks, what about paper membership form data?
It's the same. It's got the same status. It's a written record. And so don't forget that this information, it has to relate to a record. It can't be something that I walk around and hold in my head. It has to be a record, but that record can both be hard copy and soft copy, so in electronic format.
Yeah. I remember a couple of years ago, there was a breach down in Victoria, actually, where an agency had basically used a couple of skip bins and put all of their, paper records of their clients, just throwing them into a skip bin and stuck them out in the back alleyway. And so
what could possibly go wrong?
That is a no-no. You cannot do that.
No skip bins, guys.
Yeah, no skip bins, please.
Nathan asks, I work for a non-profit in an aged care Act and NDIS organization. We're purchasing equipment and system that stores data overseas. That system complies with GDPR. What advice would you give there?
If it's compliant with GDPR, it's probably meeting those sort of data protection benchmarks. What you would just need to do is inform, of course, people whose personal information you are collecting that it will be stored overseas, and then you've met that obligation with respect to APP8. But beyond that, it's always good just to impose obligations. But in terms, in a real sense, the fact that if they're GDPR compliant, they're going to probably be good enough.
Yeah, and the GDPR is kind of recognised as going slightly over our legislation, isn't it, Andrew?
Yeah, it's kind of best practice.
That right to be forgotten in GDPR, which we haven't got.
Yeah, that's right.
Couple more. Rachel asks, in terms of earnings of sole traders, for example, I'm a Zumba instructor doing 7 classes a week with no employees. I guess that would be, might get you to re-ask that one.
Yeah, I think, Rachel, unless you can duplicate yourself, or you are the most expensive Zumba instructor in the Southern Hemisphere, I don't know if you're going to be having to worry about that 3 million threshold. I suspect that you would need to have some employees or some other people to get that revenue up, because it certainly would be a lot to make off your own, in your own time if you're a sole trader and don't engage anyone else to assist you. So you should be okay.
I do think, though, regardless of the law and the 3 million, and you're absolutely right, Andrew, regardless of the 3 million mark, there is a question of trust and reputation and corporate reputation. So, our members sign up to our privacy code, even if they aren't turning over at $3 million. And they do that because they want to be best practice. They want to have those, regimes in place that protect the data that they're collecting. So I do think there is that, the framework is there for you if you choose to take it up, even if you are under 3 million.
Yeah, and also because of the nature of the industry that you are going to be holding sensitive information as well. having some sort of benchmark, even for those who aren't covered by the APPs, is really sensible, because it's an industry that really the spotlight could turn around if there were some significant breaches. And if the industry itself doesn't appear to be taking a fairly proactive approach to protecting that sensitive information, it may well be that the OARC, if they do have capacity, might do their own motion investigation into the industry to see how this, what is going to be really a very significant amount of individuals' personal information when we look at the size of your membership and how many clients and customers and patients, you know, as the case may be, or members, personal information you are actually holding as an industry. So I think that there is some real benefit in at least getting the fundamentals right, even for those who are individuals or sole traders who are holding the personal information of people that they're providing services to.
Yeah. I mean, there's corporate reputation, yes, and there's also just doing the right thing, the right thing by other people.
And there's an
reputation,
there's a reputation of an industry, and certainly
yeah,
market social research industry. I mean, I do work not just obviously in social and market research, but just across a wide range of organisations, including allied health and the like. But the industry itself, it's really important that its reputation is maintained as well, because you know you only need a few very bad eggs in any industry, and the whole industry itself suddenly comes under scrutiny in a way that you don't necessarily want. So from an industry point of view, certainly with ADIA, we have taken a very proactive approach and have put a privacy code in place in conjunction with the OARC. But even in other industries, it really is important at an industry level that you know, you do try and maintain within the resources of your members a sort of, you know, a best practice type environment with respect to this sort of compliance, because as I said, you, as do our members in ADIA, but your members do hold substantial amounts of potentially sensitive information.
Great answers. I hope that helps. I've got one last question. Do you have time to answer?
Sure.
Yep.
Yep. So this one is, how do we tell what is too long for retaining information? I guess some insurance information, I guess sort of how do we know how long we should hold some types of documentation?
Yeah, look, that's a great question. And in some ways, it's a little bit of a how long is a piece of string question. If you've got limitation, you know, where you could have, you know, personal injury actions or things like that taken against you, you're probably better holding information for the limitation periods, you know, whether they're 6 years or whether they're whatever. So in a situation where you've got a couple of different insurance policies that require you to hold information, obviously you'd hold it for the longer of the two. But then there will be information that is not going to be relevant to those sort of claims, which you might be able to delete far earlier. So it may be a case of looking into the information itself and saying, okay, well, look, you know, to manage our liability and to respond to any claim within the limitation period, we're going to need this, this, and this, but we can strip out some of the other information that is unnecessary. So you might be going back and paring back your records, even though you are holding certain records for a far longer period, because you need to do that for your own sort of compliance purposes.
Just don't do, I mean, look at Optus, right? You just don't do that. Like they've had, sadly, they've had information on clients from 10 years ago that haven't been a client for 9 years.
Yeah, that's right.
So if they're no longer a client, get rid of it. Like it's just sitting there and waiting to be hacked.
Yeah.
So just, you know, it's a toxic asset. It's not something that you want.
No, like holding on to uranium, you know.
Yeah, that's right.
It's giving you radiation sickness.
Exactly. Get rid of it. If you don't need it, get rid of it.
Yeah.
All right. Well, thank you so much for your time. Is there anything sort of final you want to end with, Sarah and Andrew?
No, Andrew, anything from you?
No, I was just going to say that, look, as I said, we would encourage you all just to turn your minds to it. you know, to the degree that you can, and I suppose I should say, to sort of spruik my own wares, that, you know, if anyone does need advice or assistance with privacy policy, then like, they're welcome to give me a call, and you know, if you know, we can't help them, then maybe, you know, we can put them in the right direction, but you know, we hopefully could.
Yeah, I ditto that, and yeah, and look, thank you very much to AusActive. You know, as you can see and hear, we're very much in favour of best practice around privacy. So we're big advocates, yeah, for doing what's right from a corporation point of view, but also from an individual point of view. So look, thank you very much for having us. It's been
Thanks everyone.
Yeah, thanks for joining us. Thanks for joining us, Sarah and Andrew. It's been very informative, and lots of people saying thank you and very informative. So thank you so much for your time, and enjoy the rest of your day. And we'll speak with you in the future. But yeah, thanks once again.
Thank you. I'm glad to be of assistance. Thanks, everyone.
All the best.
Bye.
Thanks, Sarah. Thanks, Andrew. Bye.